thank all of you for being here this afternoon. We're going to start with each of you giving us a very brief opening statement. We've gotten the written submissions, and the committee has had an opportunity to review them. So if you could make a brief opening statement, and then from there we will go into the questioning. We are on the last panel, views from federal public defenders, and let me introduce. We're going to start with Mr. Edson Bostic, federal public defender from the District of Delaware, Mr. Richard Coughlin, federal public defender from the District of New Jersey, Mr. Michael
Desautels, Your Honor.
Desautels, federal public defender at the District of Vermont, Terrence Ward, federal public defender from the District of Connecticut, Deborah Williams, federal public defender from the Southern District of Ohio, and Jim White, a federal public defender from the District of Maryland. And we'll start with you, Mr. Bostic, if you'd go ahead and make a brief opening statement.
Thank you, Judge Cardone, and I thank the entire committee for giving me this opportunity to speak to you. I started my career as a volunteer lawyer to the Public Defender's Office in Broome County, New York, as I was studying to take the New York bar many years ago. And it was there that I found that I had to dedicate myself to criminal indigent defense. But I also went through and had a very diverse career, including some time at a law firm, and also practicing as a solo practitioner and being a member of the CJA panel in the Eastern District of Pennsylvania. And then I spent about 20 years in the federal defender's system as a branch supervisor, initially in the Eastern District.
Can I ask you to pull the microphone a little bit
I'm sorry,
closer?
and then as a federal defender in the District of Delaware. And in my letter, I said that there needs to be some big change. And I said, however, I have had the greatest experience, support, and ability to get done what I believe is necessary for a defender office to do in the District of Delaware. Good relations with all the stakeholders there. In Delaware, they have not been much concerned about cutting of vouchers. And indeed, when CJA Council asked for experts, they were going to get those approved very quickly and easily. They don't always ask for them as often as we would like, but we don't have that tension. But nonetheless, I've seen things and I've heard of things around the country that make me believe that it is necessary that we have some big change. And in my submission to the committee, I did not identify exactly what that change should be. And that is because I have struggled mightily with trying to figure out where we should be, whether we should be totally independent from the judiciary, or whether we should be in a land where DSO, the Office of ODS, as I'm generally used to saying, be re-elevated and have more independence from the judiciary to help run the National Defender Program. I continue to struggle. I believe, however, that the best that can be accomplished at this time will be the enhanced ODS entity that many have discussed with you before. But I think that it ought to be with the knowledge that there will be a transition period towards something even more independent and more standalone. Thank you.
Thank you. Mr. Coughlin.
Thank you, Your Honor. I want to start by thanking the committee for the monumental and punishing schedule that you've maintained. I know you've been in Philadelphia for the last 3 days and have had hearings elsewhere around the country and really appreciate it. I'm the federal defender in New Jersey. My office actually is right across the river in Camden, and I sort of noticed that nobody came and visited or expressed an interest in coming to Camden, and my feelings are a little hurt about that, but I understand. I also live in Philadelphia, so I hope you've enjoyed your stay here, and that you have been able to get out and see a little bit of the city. I will keep my remarks brief. I've read a lot of the submissions. I've watched hearings online. I was here late yesterday afternoon to watch the last panel of the day, and basically have some of it has caused me to re-examine some of my thoughts. I've learned a lot from what I've read and what I've heard, but with respect to the basic overall question, the global independence, I've come out basically the same place in my modified Stockholm Syndrome position, which is this restoration of Defender Services, restoration of office, and restoration of the committee to its former status, along with other changes that would, I think, help correct a lot of the problems that have occurred in the last couple of years, some of which I think are due to the structure, and I think they can be overcome with some modifications and with better communication. The system that we've got or had is not perfect, but I don't think that the remedy of complete independence is worth the risks associated with that model. And I'll defer my further comments about specifics to any questions you might have.
Thank you.
Good afternoon. My name is Michael Desatel. I'm the federal defender in Vermont. I practiced also in the Northern District of New York for about 18 years in a law firm, but much of that time also on a CJA panel there, and I also worked in a federal defender office in southern West Virginia for a few years. So I've taken a stance on positions about separateness and about the anecdotal information that CJA attorneys have talked about just conflicts in terms of presenting voucher requests for investigators and experts in that to judges. And that's been talked about really, really adroitly and I think accurately. So I'm not going to address those here. Those are in written comments. I just realize after hearing a lot of the testimony here and reading some of the submissions that this committee, obviously by taking all this time and putting all this energy in, part of the reason for doing that is that there's a huge audience out there that ultimately this committee is going to address. And I think the audience needs to know some really, really important points that I've seen sort of crystallize over time since the late 1980s when I started practicing. One is that the type of case that we're talking about that gets assigned either to a federal defender office or to a CJA attorney has increased in complexity just many, many, many times since I started getting cases in the 1980s. I mean, it was viable for me as a young attorney to get a case without training, without a training panel, without a mentoring panel. Sure, I was smart enough to know to talk to a more senior lawyer. Hey, what do I do about this issue? But the issues just weren't as complex as they are now with regard to categorical challenges. And do I have to go back and seek a vacator of a previous conviction in order to even address the guideline challenge that's in front of me now, the computer issues, the electronic surveillance, analog drug cases where you have to bring in expert witnesses like that. Those are examples of the complexity that's increased greatly. I think that it's fair to say that the percentage of people who are charged with crimes, who are represented by CJA people, whether through the Criminal Justice Act, whether through the federal defender offices or the panel attorneys, has also increased in not only numbers but in the proportion of. I don't know that the public knows that so clearly. Number three, I see across the country, certainly in Vermont, and I'm sure across the country from what I understand, a really, really high caliber of attorney on the Criminal Justice Act panels. Why would somebody be in a law firm in New York City as a partner and be clamoring to get on the panel? Well, part of it is because the work is interesting, but part of it is because people really want to be high caliber attorneys and high caliber practice, and that's where they do it. I don't know that the public knows that. I think that to then translate, well, those are all, let's assume those are facts, if they are, and Therefore, a rate increase, for instance, for one remedy that this committee is looking at, obviously, as a suggestion, that translates into a necessary rate increase, that's a tough sell to the public. I get that, and I think that's part of the overall job of the report of the committee, obviously. But I think that's just a really important point for the public to absolutely know. When one of the panelists in the last session said, quote, "There's so much of what we do in this work that judges never see," I think that's absolutely true, but I think even more true is the fact that the public has no clue about that. And I hope that the report that comes out of this committee's work takes those factors into account. Thank you.
Thank you. Mr. Ward.
Thank you for inviting me, Your Honor. I'm the federal defender for Connecticut. I've been the federal defender since 2012. I worked in the office from 1990 until 2012, and for 8 years before that, I was on the panel. We're a small office. There are 7 AFPDs. We cover 3 seats of court, plus the submarine base in Groton, Connecticut. And we have a remote detention facility that's about 4 to 5 hours away. I think that my office is actually an example of what a adequately, not lavishly, but adequately funded office can do, and building on what Mr. Rico said earlier, things that judges perhaps don't see, that affect the administration of justice in the district in a positive way. We have the ability to look at some systemic issues that panel lawyers on individual cases can't do, and that the private bar, due to just the lack of a client who could pay for such things, could do. And I'll give you an example that in 2006, some months after Shepard was decided, our office undertook the project of examining the regulatory history of every drug that has ever been regulated by the state of Connecticut, comparing it to the federal schedules, also comparing local Connecticut state court practices to federal practices, with the result that we found that the Armed Career Criminal Act, 851 notices, career offender notices, things that depend upon prior state court convictions meeting certain criteria to be qualifying federal predicates, that we found that Connecticut regulated drugs that were not on the federal schedules. That Connecticut had practices where charging instruments did not specify the drug that people were pleading to, just sale of narcotics. And no one, by the way, in the 17 years of the guidelines and the mandatory minimums, no judge, no writer, no law professor, no lawyer, had challenged whether a sale of narcotics conviction in the state of Connecticut could count as a federal predicate, because it just seemed so obvious that it could. As a result of our work, I think that, if I have the numbers right, that since 2006, the government has only been able to make fewer than 10 Armed Career Criminal Act cases stick against our office. That no 851 notice has actually doubled in mandatory minimum against a client of ours since 2008. That we've taught the panel how to do these challenges. I heard Kathy Nestor and Lisa Hay testify out in Portland about the back-end savings that our offices can generate, the hundreds of years of incarceration that were not imposed as a result of work that we've done. I mean, I don't go home at night thinking I've saved the BOP some costs or that I've saved the taxpayer some money. I go home thinking that I go home thinking 2 things. That I have saved my clients years and years of unnecessary incarceration, and that I have let judges be judges. Many judges have thanked us for our work, saying that they otherwise would have had to impose a sentence they thought was dramatically unfair. What sequestration exposed, though, was how vulnerable we are, that the kind of work we did in that Shepard challenge, which, by the way, this was nights and weekends and holidays for months, but we were, again, adequately funded so that we could still maintain our caseload and make a challenge like this. But what sequestration did was took away one of our lawyers it imposed furloughs on our offices. And the kind of high-level work that we were doing, all of a sudden it became a struggle just to cover 3 remote seats of court and a remote detention facility and a submarine base that is an hour away. So I am, by that experience, I am in the camp of people who I think support DSO plus. I'd like to turn back the clock a little bit to prior to sequestration, elevate the director of the Defender Services Office back to a directorate, to have more of a voice in the budget, to put the Defender Services Committee back in charge of taking care of developing our budgets. I would just add one thing, that the reason I'm not for big I independence or for a greater degree of independence is that I come from a state where we have a public defender commission for the state public defenders, where the governor appoints 1 member of the commission, the Speaker of the House appoints 1 or 2, the President pro tem of the Senate appoints 1 or 2, and the Chief Justice of the Supreme Court appoint them. And the experience, I think, is that that office is always understaffed and underfunded. That the Thomas Commission, which was appointed by the Connecticut Supreme Court in the 1990s, found that the average state public defender handled 1,900 cases per year. Juvenile lawyers who are special public defenders, when I was in private practice, I looked into doing that work. They were paid $10 an hour. So I'm not, and the other example is our state legal aid society handles housing matters and other civil matters. And the legislature came up with, at the time, what they thought was a brilliant idea to fund them with IOLTA funds, the interest on lawyer trust accounts. And during the real estate boom in Connecticut, that was great. Legal aid was flush. In the depression that's followed since, legal aid is struggling. And when they go to the legislature to say this isn't adequate, it's like, well, that's too bad. So I'm not for big I independence, but I'm happy to take your questions.
Thank you. Ms. Williams?
Thank you, and thank you for inviting me. I think I'm the newest defender in the system. I've been in the Southern District of Ohio exactly 1 year this month. But before that, I spent 27 years in the District of Arizona. Currently, I am the interim defender for the Northern District of Ohio, just keeping his chair warm while Colonel Newman wraps it up with the Marines and gets out to Ohio to start his new job. I also had the honor of doing some panel training in the Virgin Islands a few years ago. So I've had the ability to get to meet a lot of panel lawyers. I knew and worked around the panel lawyers a lot in Arizona. I am in the process of meeting and getting to know the panel in both districts in Ohio, and met the panel in the Virgin Islands. So I've heard from a lot of them over the years and more recently, and have heard of the problems they're dealing with, and the common themes, as you've been hearing over the past many months, are vouchers, experts, jail issues, training. I have very serious concerns on the issue of independence. I think it's critical that we have financial independence from the judiciary, and I think that's one of the biggest problems that is facing the judges and the CJA Act, the CJA lawyers right now. I've practiced in front of a lot of judges over the years, and I respect them greatly, and I know they take their oaths very, very seriously. They do everything they can to avoid conflict and appearances of impropriety, but I think the current system that exists in a lot of districts, where they are selecting the lawyers for the cases and they are being asked to review and approve or not approve the vouchers for the lawyers they pick for the cases they put them on. I think it puts the judges in a horrible position. It puts the lawyers in a horrible position. And that system, in my opinion, should be changed. As I said, I strongly support financial independence, and especially after having had the experience this morning of listening to the folks who once worked in the AO and Defender Services. After hearing them testify, I think I've flip-flopped several times just in the past 3 days, but after hearing them, I did one last flip-flop. I was so taken and so impressed by what I heard. I learned a lot this morning. I believe we need independence. Please don't ask me what it should look like, because to be honest, I don't know. My deepest fear, because I love this system, it is my passion, I love what I do, in the political climate in which we live now and probably for the foreseeable future, the one thing I know I don't want is to wake up in the morning and be the next Planned Parenthood. And that, I think, is my deepest fear as we continue to discuss independence. And with that, again, I thank you for inviting me, and will do my best to answer any questions you may have.
Thank you, Mr. White.
Hi, this may be one of those moments where everything's been said, but not everyone has a chance to say it yet. No one can feel comfortable about an indigent defense system that's managed by the judges before whom the cases are resolved. Count me amongst the votes for independence. That wasn't my position when I was named a defender 15 years ago. It's changed for a handful of reasons. Most of them I think you know already. The sequester experience was scarring for most of us. I'll never forget having a meeting with my office staff and telling them that I had been told to prepare to cut 33% of them, and that I didn't think our office would survive as an institution. And I've been instructed to have that meeting with my staff. When we were saved by a compromise, the savings nearly killed us. We lost 12% of our staff and still suffered a month's worth of furloughs. The sequester fallout for DSO and DSC, you know about. I've also had the opportunity to work on many national committees, which has sort of, I guess, enriched my perspective beyond Maryland. Inevitably, those meetings where Ruben is present and Judge Chip is frequently present devolve into discussions about haves and have-nots within our system. What can we do about the immigration districts, the districts with immigration practices in Texas versus those in the Ninth Circuit in Arizona in terms of getting them staffing? The same thing, and frequently in the same circuits, how can we properly fund CJA lawyers, CJA cases, and the disparity between circuits, districts, and within districts. Also locally, again, I think I made it clear in my letter, I too feel lucky to be in my district. You met Judge Blake, earlier. I feel lucky to have Chief Judge Blake in my district, supportive of our office and the CJ. But I think we're kidding ourselves to think that there's still not a systemic problem that chills us from pushing back against even good judges. I think most defenders, I will certainly admit, that when I wrote my testimony, I thought about how it would be perceived by my judges in the District of Maryland and in the Fourth Circuit. I promise you that really good CJA lawyers are reluctant in my district to push back against decisions from our courts about their CJA budgets or their CJA vouchers being cut, because judges wield an incredible amount of power, not just in the decisions you guys make in terms of litigation, in terms of appointments, but there's all the indirect power where lawyers just don't want to be held in the bad graces of the local bench. And so there is a great deal of reluctance to push back. As others here have said today, I'm worried about the remedies. I'm uncomfortable with the alternatives, but I've come to believe that that we have to have systemic change. Perhaps the thing that best captures my view on this are lyrics from a rock song from when Ruben and I were in law school together. There was the English group, the Clash, had a song where the line was, "If I go, there will be trouble. If I stay, there will be double." It feels that.
You know,
way
I'm
to
going to
me.
ask you a lot of follow-up questions about that.
I'm pretty sure I heard that song blasting from Ruben's sound system in our first year dorm. Again, I assume I don't have to explain the metaphor. I'm uncomfortable with where we might be going if we have dramatic change, but I'm more uncomfortable with staying where we are. The current model, it seems to me, isn't fixable because of the conflict at its core. I want to echo what other folks said. I'm blown away by the diligence and the hard work of this committee. We know what the problem is. The Senate had it in their legislative history when they created this, the awkwardness of this model. The Prado committee commented the same way. Our community is looking to this committee to do something about it. Fairness in the delivery of indigent defense services is too important not to fix. To create change, I fear that the change that I anticipate that what we're going to need to fix that is dramatic and systemic change. Thanks.
Thank you. All right, we're going to begin with the questioning, and we'll start with you, Mr. Franklin.
Thank you. Thank you all for being here, and thanks for everything that you do. When we talk about independence, a lot of what we hear is the fear of independence and the fear of what could happen. I'm wondering if one thing we don't hear a lot about is sort of what do you perceive to be the benefit of independence in terms of how it affects the practice of law? And I would just ask anybody on the committee who wants to start, or on the panel who wants to take that on and see what you would perceive to be the benefit of independence. And that's however you perceive independence to be, inside, outside, or whatever it may be. Jim?
Let me state
Oh,
this
good.
I'm sorry.
No, go ahead.
Briefly, that I think in my letter I said I have it good, both in my district and in the circuit. And I believe the CJA lawyers all do also. But yet I still hear that lawyers are unwilling to file that request for an expert, especially if they end up not using the expert for the purpose described. And the conflict is real and exists. It exists where perhaps a member of my office may need to file a recusal motion and determining how best to file that, for example. Not that any judge would have ever in the past complained about any motion or any litigation that we've had, but you still go through the thought process. And I believe that something different is needed. I don't know what independence should look like. And as I said, I do believe that some period of transition is necessary as we determine exactly what independence should look like.
I'm not necessarily asking the question about what you think the structure of independence should be, but I want to know what you think the benefit of independence would be.
I think, having some confidence that the office is going to be funded year to year, and that within whatever the structure is, that you've got a meaningful voice in what that funding is going to be. You have an opportunity to participate in that formulation. That as it relates to bigger or substantive questions about whether it's sentencing or criminal law in general, that that there's a mechanism to weigh in on those issues and be able to meaningfully participate in that process as well, and to do so without fear of repercussions. Mr. Bostic just mentioned being concerned about motions to recuse, and I don't. Some of the issues that have been identified, like concern about that. If I was in private practice, regardless of whether I was representing a client who was paying me or not, I mean, I think you're always going to tread lightly in those sort of areas, and you want to maintain those relationships. And I'm not sure that those and the few instances that in my I guess 19 years as the defender, where a line was crossed. In my view, it would have happened. It wasn't the structure that gave a judge the permission to do something that I don't think they should have done. It was just a judge with a particular reason for doing it based on some other relationship, and it didn't. So, and I think sometimes there's a confusion between the two. We tend to think of ourselves as being under fire because the judges, in either as a federal defender or as a concern about the judge affecting the board, being able to weigh in. But that doesn't seem to me. That's not the issue, and it sometimes confuses things. But so I think to be able to participate in substantive law change and issues and funding is what I'm looking for in independence.
Well, so let me unpack the question a little bit, because maybe it was too broadly asked, and I'll ask you, Terry, because you talked about your experience as having been a panel lawyer. One version of independence may be that panel lawyers no longer have to go to the judge who appoints them in the case to ask for expert services, and instead they go to someone who is maybe a supervisory attorney or an administrator or something like that, who has a background in the practice. Okay, how, if at all, do you believe that would affect the performance of their work?
I think that, I've advocated in the letter I wrote for case budgeting attorneys to be spread to the district courts as well. I think that lawyers would be more inclined, to ask for or to work with a case budgeting attorney to explore the use of experts than they would to ask a district judge who's presiding on the case, can I have this expert, say it's a psych expert, and then you get the report and don't submit it. I think everyone realizes the report was bad. So I think there'd be more freedom to, as I said, to explore the use of experts if the judiciary were not involved in, or at least the judge who is presiding on the case should not be involved in that.
And I assume you would think that's a positive thing, right?
That's right.
Okay. Jim, let me ask you, because you have experience on the national level dealing with issues. You know that the judiciary has a part of it that liaisons with Congress and takes policy positions on some things. There are issues that come before Congress all the time that would affect our clients and affect our program, but our interest as defenders may not be the same as the interest of the judiciary, and you can see the conflict as far as deciding whether a position is going to be taken. If there was independence to the standpoint that the defense function was able to articulate a position and advocate for a position in Congress, that the judiciary may not do so, how, if at all, would you see that form of independence benefiting the defense function?
Again, in an ideal world, and again, I realize that's a difficult get, but I think that's what our community would most want. DOJ certainly has it. We would like to have the ability to have that impact. clemency work is an example of where we were denied the opportunity to do work that we thought would make a big difference for our clients, and were denied that opportunity. We would probably want to advocate for a legislative remedy for matters like that. Can I take a minute to address your broader question
Yeah,
that you
certainly.
mentioned at the beginning? What motivates me, and I think what probably motivates all of us, is we're trying to sort this through. The reason why I would love independence is I think it would make a difference for our clients. I think you've heard the evidence over and over again in terms of, from the defenders in Texas who drew the contrast between how they're funded versus the District of Arizona is funded. You've talked about the chart with the use of experts by CJA attorneys. My district, I think, is doing well compared to its peers. I think we're in a little bit over 20%. That's not very good. The fact that 80% of the CJA representations in our district don't have an investigator, yet an expert. I would hope that we'd be able to improve this system so that we could raise that bar. Again, the question that I think Ruben raised at the end of last session. I mean, one of the ways I evaluate my lawyers is if you're not using experts, there's a problem. There's either a lack of energy there, a lack of creativity, or a systemic problem in my office that in all of your cases, you're not using an investigator or an expert. That means you're just taking what the government gives you. And that's not what we do.
Thank you. One suggestion that we've heard as an alternative is to move the functions of panel administration and voucher review, expert approval, that sort of thing, into the defender's office. And that could take several forms. It could either be the defender or defender employee, or it could be a panel administrator or somebody who is somewhat walled off, if you will. And I'm just wondering if any of you have thoughts or perspectives about that in terms of, number one, its feasibility, and number two, its impact on the functions of the defense.
Here would be my fear, is that if we had to go through another sequestration, that I have a small office and everyone is sort of a jack of all trades, and I need every one of those people. But if sequestration came and we had a panel administrator or whatever you want to title the person, who didn't actually do any work for our clients, but was strictly for the panel, if I had to have a cut, I'm sure that they would not let me cut the panel administrator. I'd be cutting a lawyer or a paralegal or an investigator that does work for my clients, and I don't want to be in that position.
Sure. What if that position were sort of separately funded, or a different appropriation from the defender, your office appropriation, but just housed in your office and received whatever support or osmosis or whatever it may be within the office?
I would just be afraid that even if it started out that way, that if a new sequestration came, that the rules would change and they would say, no, you have to cut X number of dollars from your budget and we're not going to separate out people, but you can't lose that person. So I'd just be afraid that it would morph over time and that it would end up hurting my clients.
Anybody else have any thoughts on that issue?
Yesterday, a woman spoke. Was she from AJ's office? The panel administrator?
Western Washington.
Okay.
Yeah, Western.
And over the past year, I've heard several other defenders talk about having panel administrators in their office, even people who are doing the voucher reviews, and how they have walled them off and made sure they have complete independence, even from the defender, to allay the fears of conflict. In Arizona, we administered the panel, but that was one piece we could never really wrap our minds around. If we don't do the voucher review, don't want to do the voucher review because of the inherent conflict. But it sounds like, and I know you've heard from various defenders who have done that, there are ways to do it. I think that is a very feasible alternative, assuming there was a way to get that position into an office because I have work measurement spinning around in my brain right now. So it would have to be a position that would somehow get funded and come to us from the outside so as not to be subject to work measurement and future sequestration.
Well, I'm not sure who has case budgeting attorneys in their circuits, but the case budgeting attorneys are funded through an appropriation of Defender Services, yet they're court employees. And so a model like that might be something that would be an option. I'm curious, though, do you think that the placement of that individual, and let's just set aside Terry's concerns about funding right now, but let's assume, do you think that the placement of that individual in the Defender's office would give that individual more legitimacy and credibility than the placement of that individual within the clerk's office, or do you think it matters? For anybody who wants to comment.
My somewhat knee-jerk reaction is that it might give some more credibility being within the defender's office. At the same time, it might make some people question, well, how can you be avoiding conflict if you've got a co-defendant with me and we have a 20-person case? So I don't know. I know in Arizona, many years ago, the court brought in a lawyer to do voucher review and set up a system, and I honestly don't know if he's still there, but at least for a period of time, I heard from the panel lawyers that it did create some relief, but that was quite a long time ago.
I think that
No, I'm sorry, go ahead, Rich.
I think that the current system is awful. I think having it in my office would be less awful because there are risks I think associated with it in terms of appearance and conflict. And I'm in New Jersey, and I would be concerned about suddenly being invited to all sorts of beach houses and golf clubs and showered with gifts and
Concrete shoes.
yeah, and then you have to, everybody's got to be checked for a wire and so forth. So it would get complicated. But it would be, look, if it took the judges out of the business of reviewing requests for experts and investigators and so forth, I would take that on, and I think that would take it on because I think it would help the system. I think it would help the clients immeasurably. I'm in a district where vouchers aren't cut. Expert services, I looked at the numbers. I'm not quite sure that they match what the clerk's office tells me, but whatever. And we've done a lot of training on using experts and getting people to use experts. And the last couple of years for the amount of money spent on CJA experts in New Jersey was 1/2 of the total for the circuit in 2014 or 2/3 in 2014 and 1/2 last year. And even with that, I know that they don't ask for investigators as frequently as they'd like to because they don't want to go through the paperwork. They don't want to reveal what exactly they're doing. They're uncomfortable with making a sort of more general request when they can't list the witnesses who they want interviewed, but they'd still like an investigator, someone to go through and work with the client with them, and don't want to explain that to the court. So and all of that, not being able to do that hurts clients, and it makes the practice much more difficult than it should be. I think, preferably it would be something independent along the lines of the case budgeting attorney, but, if you put him in my office, we'd work out something.
Thank you.
All right, Dr. Ruck.
I may be beating a dead horse here, but can I follow up on that? I'm really concerned about the lack of use of experts. And Mr. Coughlin, you just talked about that and them not wanting to do the paperwork. What kind of reason is that?
Well,
really?
what I mean is, in the marginal situation. So I talked to a panel lawyer today, called me about case budgeting and about he had some questions. He was talking to the case budgeting attorney in the Third Circuit, Renee Edelman, who's been tremendous and been a tremendous addition and a huge help. And so I asked him about expert usage and when it is he wouldn't ask for an investigator, and it was basically what I just described. If he's got witnesses who have to be interviewed, he'll ask for an investigator, and we'll get it. If he had a child pornography case recently that went to trial, he didn't get an investigator.
He didn't get it because
did
he
not-
didn't ask or the judge denied it?
He didn't ask. And he didn't ask because he didn't have any witnesses who had to be interviewed. The discovery, he felt he would have liked to have, what he would have liked to have had an investigator do, or a paralegal. And, in retrospect, he probably should have asked for a paralegal. Would be somebody who could review the evidence with him, review the case with the client, and maybe would have seen things that he didn't see. But it's more of an amorphous, less task-oriented request that he felt might not be honored. He did get a psychologist. He had a psychiatric workup done, but he didn't feel like writing a justification, and $2,500 wouldn't be enough. He'd need more than that. So it became he felt it was optional, so he didn't. It wasn't necessary. He couldn't describe it as necessary. It would have been good to have.
This makes me think about a number of things. One is the quality of the representation. It makes me wonder about training issues and something that Chip's been talking about, Mr. Finsley's been talking about, Judge Finsley. Just the overall use, of experts. Ms. Williams, you mentioned that in your written testimony as well. What we've seen across the country is that the rate of the use of experts is incredibly low. If you were doing your staff, you would, I think, and what we've been told repeatedly is always have an investigator and a paralegal probably assigned every case, and yet we don't see that with the panel attorneys. And it really makes me wonder about the quality of representation being provided by the panel when they're not doing this. So is it a training issue? Is it a culture issue? Ms. Williams, you want to speak to that?
Yes, if I may. My panel rep in the Southern District went to the gathering, the CJA rep gathering in San Francisco, and when he came back, he sent out emails to the panel talking about some of the things he had been hearing, some of the themes, and also that he had learned that the panel lawyers in my district are well below the national average in use of experts. I can't tell you the percentage, but they're well below. And I asked him, what are your thoughts? Why is this going on? Because I'm sure there are many reasons. And he said, among other reasons, there is a general fear of spending money because there is a concern that the judges, a concern by the lawyers, that the judges see them as competing, if you will, for the same pot of money.
But I'm sorry to interrupt, but Mr. Coughlin and Mr. Bostic, I think just said, if I heard them right, that in their districts at least, the judges are totally supportive. So how does that fit?
Well, and I think this concern in particular comes from probably not anything that a judge is saying outright, but a feeling, a perception that is arising when judges make critical comments on requests that are made, and the lawyers start to really key into that and become sensitized to it, or when a judge questions the reason for an expert or the amount requested, there is a self-policing that starts to kick in, and there is a fear of reprisals. Well, the judge said the last time I asked for, let's just say, an investigator, I got the impression they thought I was asking for too much or that I was asking too often. So now I have another case, and maybe I shouldn't ask again because maybe the judge thinks I'm spending too much money. It's, I think, perhaps in part a self-fulfilling prophecy, but there
We've
are
heard a lot of
repeated
different
themes.
information from around the country, but just within this room, I've just pointed to 2 federal defenders who've said their judges are completely supportive. Mr. Skipper testified up and down, judges in the Eastern District are completely supportive. So where is this? And we've heard a lot of people say that judges are completely supportive of investigations.
Let me ask a question to try and unpack that, because I think this is, let's turn to you, Rich, and you talked about a specific case, and you said that this person would have liked an investigator, thought it would have helped them in their representation, but didn't request it. There's got to be some disincentive, because of course, if there weren't any, there'd be, so what's the disincentive to that attorney to ask for the
The
investigator?
disincentive is the immediate just filing the papers. There is also, regardless of the culture of being supportive, there is a concern about being judged about what you're asking for, and are you asking for too much? And you know, and I think some of that is because of the structure. Some of it is continued fallout from sequestration, general atmospherics in the country about how public money is spent, being concerned that you're going to be identified as somebody who's wasting government money or spending it, not being as thrifty and creative as maybe you should be. And you know, and it's that, in part, that general atmosphere that you know, we live in a time when people don't want to fund education. They don't want to fund infrastructure. They don't want to fund research and development. To have a standalone federal defender organization going to Congress and having members of Congress vote up or down on that specific budget, as opposed to a budget that voting on a judiciary budget.
Mr. Coughlin, I'm
leaves
going to
me-
read
makes me-
your testimony, your submission. Let me make sure it's yours. It is. Perhaps most importantly, I am not aware of any instances where someone from my office or the CJA panel has ever hesitated to raise an issue or make a colorable argument on behalf of a client because they were afraid there may be negative consequences for the office, or in the case of panel attorneys, their membership on the panel.
Right, and making a colorable argument, raising a legal issue, a challenge to a judge's ruling, whatever it is. Yes, I think that's true. I stand by that. Is there this cloud over the process? Yeah, I think there is. I think even in the best of districts, there's a cloud, and I think I've said that in my written testimony that that is a systemic problem that should be addressed.
If I could just add here, I went to Quinnipiac Law School this fall because I thought, well, maybe the reason people aren't using paralegals is in little Connecticut that there aren't this big crowd of paralegals out there waiting for work, and maybe lawyers don't know where to find them. So I went to Quinnipiac and said, would you supply law students or recent graduates, especially in a tough job market, and pitch to them that this would be a great opportunity for your graduates and law students to connect themselves with criminal defense firms, and would you train people to be paralegals? And then notified the panel that I had Quinnipiac standing by with law students ready, willing, and able. I've had no requests for a paralegal. I don't understand it.
If I may, last year in Maryland, I led a breakout talking about the use of experts with a member of DSO. And there were many CJA representatives there from around the country and defenders. And the discussion centered upon, from the CJA representative, concerns, fear of asking and fear of not getting time and time again and keep pushing the envelope. And fear whether they'll remain on the panel. And that's what they reported. So while I have it good in my district, and in all my CJ, the panel members are saying, we asked for it, we get it. I'm just reporting what was said from people around the country.
And I'll report hearing the same thing. I mean, in another exact comment, the way that Terry Ward explained it, where literally people have told me if I get an expert psychiatrist and then the report doesn't get offered in court or to the judge even pre-trial, then I'm concerned that the clear take on that is that the report was worthless, or at least it wasn't favorable to the client, and then that maybe reflects on the attorney for having gotten or sought an expert that wasn't worth his salt in the first place, or worse, to the client's disadvantage, it demonstrates that there really is not a mental health problem there that wanted to be advanced. So I hear the exact same types of things.
Can I just ask, or say, I hear everyone here say, if we ask for it, we get it. But what's happening is they're not asking for it. And so we've tried to discover, is it a training issue? From what I hear from here, and I think generally it's not a training issue. It is they're not asking. If you ask for it and you get it, and only one person asks and they get it, well, of course they're asking and they're getting. But that doesn't tell us. We've seen 3% use of experts. We've seen 5% use of experts. And so if 5 out of 100 cases are getting asked for, then of course they're getting it. But it should be 65%. So if 65 or 100% were asking for it, as in your offices, would they all get it? Is that what you're all saying? If every CJA attorney that in every single case, like you have the opportunity to do in your offices, ask for experts, are you telling us that the judges would approve that? Is that what you're all saying when you say if they ask for it, they get it?
I don't think so.
And why do you not think so?
Because I think at some point there would be pushback because it's different and it costs money, and the judges would be concerned about the appearance of a CJA budget run wild in the District of New Jersey. So how it would play out exactly, where the line would be, I don't know. But I think if that occurred, there'd be pushback.
Let me ask a question to those of you who say, in my district, if my CJA panel attorneys ask for it, they get it. Which is what you're really saying, if they ask for it, they get it, but they only ask for it when they're absolutely sure they're going to get it because being turned down has some negative consequences. Is that what's being said here?
That's not what I'm saying. At this point, from what I've seen and what I've been told from my panel members, where they ask, they ordinarily get the appointment of the investigator or the paralegal or what have you. And in some cases, even co-counsel on a complex fraud case. That's my experience. But as I report to you from what I learned in terms of talking to other CJA representatives from around the country and other defenders as well, that's not happening in their districts. as to whether every CJA panel member asks for an expert on every case, whether it be sentencing, mitigation, or otherwise, and they'll get it, I do not know.
I will speak, if I may, from my past experience. All it takes is one, maybe 2 times for a panel lawyer to be told no, and then it's review time, and a judge says, oh, that person always wants A, B, C, or D, and then all of a sudden that person is no longer on the panel. That sends a very loud message, and it runs wild through the panel, and you can bet that requests for assistance will drop off immediately because the message is very clear.
I think we need to distinguish between experts, paralegals, investigators. I think in my district, it's really been encouraged. Jerry Tritz, the case budgeting attorney for the Second Circuit, came and addressed the panel at my request and talked about how he views paralegals as a wise use of money, that instead of listening to 100 hours of wiretaps for an attorney at $125 or $127 or whatever it is an hour, that a paralegal could listen, under guidance with, we're looking for these kinds of terms or whatever, at $25 an hour. He's encouraged it. I think that if any CJA lawyer in my district asked for a paralegal, it would be granted. I think if they asked for a psych expert in every case, it probably wouldn't be granted.
Can I just weigh in for a second? I love that you're focused on this issue because I think how you resolve this issue and unpack the culture issue. I mean, my view is the culture is that the system has somehow created a culture within the CJA attorneys not to go for it, and that it's a fundamental flaw with our model. Is certainly my position in my testimony today. There's an anxiety about going forward. There's an anxiety about being rejected. There's an anxiety about being high maintenance, and that you're either going to get less appointments or get kicked off the panel. I would be somebody, Judge Goldberg, who would say that my court is supportive, but I will also tell you that attorneys in my CJA, really good CJA attorneys, strong CJA attorneys, are reluctant to complain about decisions made against their interest in the context of a voucher or in the context of a budget. And I believe it compromises the quality of the litigation. I believe it's on occasion unfair to the individual attorney in terms of their compensation. Again, I've had that conversation within the past week with a woman CJA attorney that I admire a great deal, and I know my court does. She had to make a decision about whether she was going to complain about it. She wanted confirmation from me that it was wrong. I gave her that. I suggested she complain about it, and I don't think she will, because she doesn't, even with her stature, I don't think she wants to be deemed sort of high maintenance or a squeaky wheel to be complaining about a judge or a CJA administrator.
And I'm not quibbling with any of you that that's not a very thoughtful, plausible theory. And I interrupted Dr. Rucker, so I'll take it back to him, which is his point was, I think he was trying to say to you, okay, the system, as you've explained it, it's inherently set up so it creates a situation where people aren't asking. But I think what Dr. Rucker is asking you is there another reason? Is it maybe the CJA lawyers just aren't doing their jobs? Could that be part of it, as opposed to this inherent system, evil system where judges have to approve vouchers? Is that possible?
Related to that, again, I would suggest that it's all a systemic problem. I think there are probably instances in which there's lawyers who aren't used to working with experts and maybe just aren't trained that way. That's still a systemic problem that we don't have the right people on the panel. I guess the other observation I'll make, and it's certainly probably something I talk to my new attorneys about, is for the most part we pick our battles as defense lawyers. And again, my sense is that the CJA lawyers are not picking the battle to fight over getting an investigator, over getting an expert in many, many of our districts. Again, I think my district is at the higher end of the numbers, and I would still say it's a disappointing number that compromises the quality of justice in my district and the integrity of the system.
And I don't necessarily agree, and I've heard this come up quite a bit today, that it's a training issue, because across several districts now, I see many cases where, let's say there's a multi-defendant case and the CJA a group of CJA lawyers and the defender is able to get in on the case and stay in, the CJA lawyers are happy to have us. Why? Because we bring resources that they can use. They know that, they welcome it, and in my experience I've seen, they know how to use them. So I don't think it's a training issue. I agree with everybody that we're talking about a culture issue that has grown over time.
Dr. Rick?
Well,
like-
all right, I have more questions, but let me just ask one. Let me go to Mr. Wyda. In your written testimony, and it's sort of related to what we're talking about here, and it's a culture thing as well, I think. You talk about self-cutting, and we've heard that before by attorneys. And I see some of you nodding your head yes again. How prevalent is this?
That's totally widespread in my district. Again, I think any survey, honest survey from our CJA lawyers is, it's either has to do with delays in payment coming from the circuit. When you go through that process, it's just easier to take whatever the number might be, 8,000, 9,000, then go for 12,000. But I think there's anxiety about review from the circuit, more so than from our district court, where we have a good, again, despite what I think is my honesty about sort of some of the challenges, it's a good district with a CJ panel administrator and a decent bench, but beyond decent bench. But it's widespread in my district.
Any of the others of you like to comment on that? How widespread is it?
I really don't know. I don't have a district where there's a lot of voucher cutting. So I don't know if that's because panel lawyers self-cut. We almost always exceed the cap. We have a remote detention facility that for lawyers, just a single visit to a client for an hour and a half is more than $800. So, to see a client, 10 times during the course of a case is going to push you over the cap. So I don't know how prevalent it is. I'm not sure, other than surveying the panel, there'd be a way to know.
Okay, I'll use my time. Thank you, Jessica.
All right. Ruben, any questions?
Yeah, let me start with you, Jim. And I'm-
Microphone.
let me start with you, Jim, and I hope
Does
you
this
don't.
have to do with our music taste and the
No, I'm not going to go anywhere that easy. I'm gonna put you on the spot a little bit because one of the things we've been hearing a lot about, maybe this is an unfair characterization, but I'll say timid panel lawyers who are not asking for the resources they need and maybe not fighting some of the battles they ought to fight. But in your position as the head of the capital trial expert panel, you've viewed a number of situations with what we've kindly referred to as problem districts, with defenders who are not willing to fight certain fights and not willing to do certain things, sometimes just recommending appointment of not very good lawyers in capital cases, sometimes in their own handling of capital cases, not fighting those fights. Could you describe a little bit of what you've seen over the 10-plus years you've been head of capital trial expert panel with regard to defenders in those circumstances?
Well,
I'm not asking you to
No,
name names, but
I won't name names. And again, probably even with in the context of the CJ lawyers, but again, with the defenders, I think people are doing the best they can within their cultures. They're hamstrung by the cultures in their district, but there is, again, the conversation that I alluded to about the haves and the have-nots usually comes up in the context of our capital work. I think the Spencer report bears this out. The disparity between funding between districts in certain regions in this nation versus the funding given in other districts is incredibly dramatic. And again, I think the Spencer report makes the case, or at least the supplement to the Spencer report makes the case that it's making a difference in outcomes. And again, it seems to me it's at the core of what I've described as sort of the fundamental flaw in the system, is that we've got a totally deregulated system that turns on individual judges' appreciation of the defense function. So if you're litigating a capital case in one region of the country, you could end up with a wildly differently funded defense than if you're in my district or in this district or in New York, as you heard earlier. And again, some of it may have to do with the cost of living in these districts, but the funding of the mitigation case, the funding of the investigation case is dramatically different, frequently depending on geography and most often circuit.
Let me, and this would be for those of you who are suggesting that what you'd like to see is kind of DSO.
Microphone.
What you'd like to see is DSO plus a return to the halcyon days of yore, when DSO was ODS and when the DSC had control of the Defender program. I want to catalog a few of the problems we've heard about. Interference by district judges with Defender management of their office, conversions of CDO to an FPDO, circuit limitations on attorney hires by Defender offices, panel voucher cuts which result in limiting the scope of the representation of the panel lawyers, what we've just been talking about, the lack of the refusal to support or to fund experts, be it investigators or other more what we would more normally term experts. Circuit judges having budgets in capital cases that have been approved by the district court judges. And finally, what you heard this morning from Steve Asen, Dick Wolf, and Bob Burke about the institutional conflicts that have limited what the Defender Services Committee in asking for the budgets it believed were needed to support the Defender Services program. What additional structural changes or mechanisms would you put in place to try and address all these problems which have existed existed prior to sequestration, existed prior to the jurisdiction stripping of DSC, existed prior to the work measurement study? What for those of you who want DSO plus, what would you do to address those problems? Terry, let's start with you.
It's hard. I would say, having sort of grown up in this system for all these years, that prior to sequestration, I think defenders were generally pretty happy with their offices and the ability they had to manage them. I'm not saying it was a perfect system by any means, but I don't know if there's, we've been talking about training.
Does this sound like a system they should have been pretty happy with? I mean, I just described a system before these things happened.
But I'm not sure that was uniform across the country.
No, I'm not saying it. So what if it happened in 20% of the offices? Is that a system we should accept as tolerable?
Well, we've been talking about training a lot. Maybe judges should be trained to more appreciate the defense function. I'm not sure the system needs to be thrown out to fix the problems in 20% of the offices. I don't know. What I would say is that I was a lot happier prior to sequestration than since, and it seems like some of those things that have happened have really happened since 2012.
So in the medical community, if 20% of surgeries went awry and patients' lives were upended and damaged, I think the medical community would consider that a systemic problem. We're dealing with people's lives. Why isn't 20% a failure rate that's intolerable?
It is, and I think there are things that could be changed. Perhaps in the statute, the circuit setting the number of lawyers and not letting basically the defender decide how many, if you have a pot of money, how to spend that money. That could be changed. I think the use of case budgeting attorneys and perhaps taking expert approval away from the judges. But But the alternative of big I independence, as I said before, I don't think if you look at my state system that that's worked better than what we had before. I think it's much worse.
Okay. For a number of years before sequestration, and at Defender conferences and when I was on Performance Measurement Working Group, we were told, and this occurred sort of serially, that Congress and the budget people in the AO saw a program that was out of control, and they're concerned about the ballooning budget and why are these budgets going up so fast. And there was requests for data and statistics, and defenders didn't want to give the data, didn't want to give the statistics, and had a history of relying on stories about why we need this money because of what we do and so forth, and so there was a real reluctance to allow any data to be released. At one point, the head of the IT section in the Defender Services Office did a study, and I want to say it was in the late 90s, early 2000s. He was asked to provide numbers, and he suggested his analysis showed that we were 2,000 FTEs short of what we should be funded at, and so that was dismissed. And then we did RAND as an effort to provide data and a reason for why the costs were going up, and explaining that the cases were changing and so forth in the discovery. And that was sort of suggested, or the impression that we got was, well, they must have pulled the wool over Rand's eyes and convinced them that they really need all this money and all this staffing. So then we went to we're going to get to the heart of this, and the work measurement study is going to show us exactly what's going on. And for the most part, for some offices, not so much. For other offices, probably not much change. For others, should have more people. And it occurred to me that throughout all that time, the defenders never had a seat at the table. And maybe it was that other agencies going to Congress were providing data and statistics, and that's what the appropriators were used to seeing. And we're getting it on the end from a budget office within the AO, that our perception, in maybe a slightly paranoid state, was out to get us and out to do us harm. Now, maybe it wasn't all goodwill and good-natured, but it seems to me that we should have, if we had been involved and had a membership on the Defender Services Committee, had access to the budget office, had access to Congress, that maybe things would have been different. Maybe not, but
Starting to sound like a proponent of independence.
No. What I'm suggesting is that we stop being treated as if we're court services, and that we have a real stake in this, and that we should be a part. We should have membership in these bodies. And one of the other sort of, it's occurred to me, there were questions yesterday about, what could we do as a trial, as a model or whatever to test this out. And, maybe you have a standalone, either within the judiciary or a corporation along the lines of PDS that is a national defender office in terms of policy and lobbying on criminal justice issues. Maybe that's the vehicle for an ex officio member of the Sentencing Commission. And if it's a corporation, it's by, like PDS, the board would consist of federal defenders and other stakeholders. And, maybe it would take on training. Maybe it would take on Supreme Court advocacy or any number of functions. But would not implicate the overall defender budget, because that would still be separate. So Congress and some congressman who just had a terrorism case in their district, who's happens to be on the Appropriations Committee, isn't in a position where they're, if they choose, want to grandstand call or make an issue of the millions of dollars that were spent on the defense in that case. And so the defender budget would still be separate. You would get some of what you're looking for from independents in terms of access to Congress on legal issues, access to the Sentencing Commission, and so forth. But you would also avoid what I see as the specter of a defender general, somebody who is, look, it's not, no office is perfect, and we should do more sort of introspective looking, but you would avoid that top-down, this is how things are going to be, which is something that I'm concerned about in some of these other models that have been suggested. So that's what I thought.
Take it away, Judge Gold.
Judge
All
Gold.
right. Dr. Rucker, I have one question, and then you can have my next one if you want. Actually, I have two questions, but you can take one more.
Or maybe three.
Just one more question.
Just one more, famous lawyer phrase. Just one more question. So it's late. My mind was wandering a little bit. I was sitting here thinking, I was looking at my good friend Lee Skipper in the back, head defender, Philadelphia, 6 defenders here. My new good friend Reuben Kahn sitting next to me. My other new good friend, Catherine. It is late. Catherine, you're sitting in front of a sign that says Edward Prado. That's not Judge Prado. Surrounded by federal defenders. I'm a former AU was saying, you know what I was thinking? I was thinking, thank God I'm not going to call a cooperating witness to testify right now at 5K. This would not go well with all this defense talent here. So here's my one question. And it's a hypothetical question, judges get to ask hypothetical questions, and so do committee members, so I have the double luxury of asking a hypothetical question. So you have to accept the facts, even if you think they're a little ridiculous. Suppose we could effectuate change in the following way. We would take all of the decisions regarding resources away from the judges. So there would be an independent entity that would approve all the resources that, and I should be more precise, for CJA lawyers. So investigators, paralegals, experts, DNA experts, that kind of thing. Vouchers, all of that, judges don't do it. Someone independent from judges does it. We would elevate, my hypothetical change, we would elevate the DSO back to where they were. I don't understand the organizational chart and how they were demoted, but I get that they were demoted in some way. Make them a directorate again, and make sure that they had access to budget discussions and were at that table. And we could get money for substantial training for both defender offices and CJA lawyers. Under that hypothetical, would any one of you still advocate for independence?
Would you repeat the last part after, would any of you have?
Would any of you still advocate for independence? And by that I mean taking all the defender services and everything to do with public defenders and CJA lawyers and create a separate entity outside of the umbrella of the judiciary?
You know, before I came this morning and listened to Dick Wolf and Steve Asen and Bob Burke, I would have been with that hypothetical 100%, and I think it's what many of us consider the DSO plus model, so to speak. But after listening to them and learning from what they had to say, looking backwards, I'm not so sure that I wouldn't still vote for complete independence.
Why?
Because after listening to them, I feel that I now have heard more of the backstory of what things looked like in the AO and in ODS, as it used to be known, what was really going on behind the scenes as opposed to what it looked like from where I sat. And in all those years, I was an assistant at various levels, not a defender. Like I said at the very beginning, don't ask me what form I would propose, because I'm not sure what it should look like.
It frustrates me a little bit because you're the experts. We want to hear, you can't say there's problems, but don't offer us solutions. This is why you guys are here. You're the experts in this field.
So Judge,
Go ahead.
I don't, I'd like to address, so if I understood your hypothetical correctly, I'm assuming that the circuits still control the number of assistants, the circuits still appoint the defenders, and so I'm still for independence. If I'm understanding your hypothetical and the basis
You are.
the basis for your hypothetical is that somehow we can't maybe totally trust judges to use their judgment in the CJA context because maybe they don't understand the defense function or appreciate it enough to make the decision.
Judges are out of that function, in my hypothetical.
Right, but I understand. But if the reason why we're doing that is because somehow we don't think they have the expertise, why would we have them control the defender offices, the appointment of the defender, the
If I added to
decision
my
about-
hypothetical that all the offices should be community defenders, then what?
Again, if they still control the number of assistants going to that office, because again, I watched the testimony.
Defenders. They have no say as to how many lawyers I have.
But now you have no insurance, right?
Right.
Well, yeah, there's that.
But Judge, in your hypothetical,
Or
the
retirement.
the new director reports to the administrative office head, but the defender budgets are within the judiciary budget, right? Under your
Yes.
hypothetical, yeah.
Yes.
Yeah, I'd still vote for independence, just because I think there's just an inherent tension, conflict that's always going to be there because of that fact. And so what would the model look like? It would have to look like something like the admittedly defunct, Legal Services Corporation. That'd be some kind of a corporation that Congress wouldn't be able to just derail, defund. And I understand that's the bottom line, judiciary sort of position that, we're here to help you and we can get the budget through when you can't, you're on your own. I understand that. That's really clear. But in my hypothetical, it would be a standalone.
So you get all the things offered in my hypothetical. We go to Congress for your funding, but still you want out.
Because there's an inherent, and it's not because I've had bad experiences with judges, just because I think there's an inherent conflict with that has been explained in testimony by other people. So.
Judge, I consider myself pretty strong for independence. I probably want to deliberate a little bit over this. There may be so much benefit from that hypothetical that I might be willing to sacrifice. Maybe I'm now channeling my inner Donald Trump. I want to make a deal. But
Don't obsess over it too much because I don't have that much authority.
But I like the way you're thinking and making a lot of progress. I agree with Mike that there's, in the ideal world, we would be able to advocate for our own budget. That was at least one of the consequences of the sequester, was that we felt, poorly represented on the Hill. What led to sort of the way, to the devastation in our office and our programs was that we don't think we were well advocated for. But again,
What if you had like a pass-through budget? In other words, I don't believe that the budgeting office at the AOs has anything to do with, for example, sentencing commission budget or FJC budget. So what if you had some power to make up your own budget and it went up with the judiciary's budget, but it didn't necessarily get touched by the judiciary?
That, I mean, again, to the solutions question, that's one of the solutions that seems appealing. I would also suggest, I think it was in my testimony and others as well, that the Public Defender Service in DC, a much more modest budget, but, seems to I mean, that is a very effective, well-funded defense organization that has the independence that I think we would so desire. I know there are other models out there. Again, so I think there are models out there that could work. One last comment. Again, I think I've alluded to this already. These meetings that Judge Chip and Ruben and I have been in, and it kind of goes to Terry's response, the discussion with Ruben over the 20%. I would say one of my primary motivations for independence is we're a national system of justice. We can't tolerate a different standard of justice in Texas and in Missouri than you get in Connecticut and New Jersey and Delaware. And I really hope that this committee will make a strong statement.
I think that's
not
a
justice.
great point. What you just said.
If I may, if
Even a
we-
blind squirrel finds an acorn.
If I may, if we could get all those things and ensure a seat at the table for a defender representative, it would make my struggle a whole lot easier. But also, I think that then we would have to, at some point, finite point in the future, look at what we have, having gotten all of these benefits, to see if they work well and if it has made the difference that we believe those changes may make.
Okay, Judge Cardone, I cede my time to Dr. Rucker.
Does anybody back there have any questions?
Yeah, I don't doubt that there is a legitimate fear of reprisal or retribution if lawyers feel that if they make a request for certain services and if those results don't come back to the court, i.e. a psychiatric exam, that the judge would assume that the report was negative and therefore somehow use that against the client. That may occur. But what I find very frustrating is that while these scenarios are given to us as to why panel lawyers are not making the request, we have very few concrete, actual situations presented to us showing that that occurred. So is it based upon actual concern as a result of things that have actually taken place, or is it a paranoia based upon supposition?
Judge, if I may, my new district, in fact, both of the districts in Ohio, I know that they do not have a voucher cutting problem. But speaking from my past, where there was a growing, huge voucher cutting problem, experts have now and are now refusing to work with panel lawyers because they've had, the experts themselves have had their bills cut. And so they don't trust that the panel lawyers will be able to get them paid, whereas if they worked for the defender offices, they know they're always going to get paid. The lawyers, the panels had, the panel lawyers have experienced tremendous voucher cuts. Some of the very top layer of the panels over the years have dropped off because they just couldn't tolerate not just working for, and I've had lawyers tell me, I can no longer work for free or pay the court to let me take the case. I can't do it anymore. And just have seen tremendously good lawyers drop off for that reason. So
We need those testimonials. I mean, that would be very helpful to us in making our case that there are systemic problems that need to be addressed.
And
But it's kind of, I think it's going to be very difficult for us to convince the powers that be that there is, in fact, a legitimate problem that needs to be addressed if we don't have that documented evidence.
And unfortunately, Judge, I suspect you won't hear those testimonials, because if somebody is pulling back on what they need for representation because of the fear of what's happening to people around them or even to themselves in the past, they're not going to be very inclined to come forward and make the bold statement that you need to hear.
Any other? Okay, Dr. All yours, Dr.
Don't look at me. I'm not saving you.
He's got a list, okay?
No, I don't have a list, but
Rich and I are going to jump in as soon as you.
Okay, I'm going to change totally. I kind of hesitate to do that, but one of the things we're supposed to be looking at is diversity. And we have not had a lot of testimony about diversity, so I'd like to hear you talk a little bit about the diversity within your office, but also especially the panel, because we don't have data on the panel at all. So can you talk a little bit about, are you satisfied with the diversity in your office and on your panels? Mr. White, let's start with you.
I don't think anyone's, I'm not sure too many defenders would say they're satisfied, and I'm not sure we should be satisfied with the diversity in our offices. I will say we are making progress. I think we've pushed hard, and I think I'm proud of the fact that our community has pushed hard. You can go to what we call the Baby Defender Conference, the new assistant conference, and see a great deal of diversity there. I'm proud of my office. I think my assistants were over 60% women. I think 35% people of color, 20% African American. Compared to the U.S. Attorney's Office in my district, we're wildly more diverse. I think the panel in my district, I know my judges are committed and trying, and there's an ongoing conversation about it, but we have a longer way to go there. I think sometimes because our panel is fueled by alums from our two offices, and you're not going to get much diversity from the alums of the U.S. Attorney's Office in my district.
Ms. Williams?
In my prior office, we had, over time, John Sands has built a phenomenally diverse office and continues to do so in every possible meaning of the word diverse. The panel there's a very large panel in Phoenix and a very large panel in Tucson. Because of the demographics of the state, in part, I would say that the panel in Tucson might be a bit more diverse than the panel in Phoenix, but the panel is not as diverse as the Defender Office. In Southern Ohio, it is not as diverse as I am used to, but I will say that I'm working on it. I'm very committed to it because that's what I was raised in, basically. So it is in progress. The panel does not seem to be particularly diverse. I do know that the panel underwent a reduction in size a couple of years before I arrived, and I have been told that the panel lost some diversity at that time. But I agree with Jim. It is something that none of us are fully happy with, but it is a work in progress, and it's something we're all very committed to. And it's a struggle every step of the way.
Thank you. Mr. Ward?
3 of my 7 AFPDs are women. There's 1 African American male. All of my 3 paralegals are women. And 1 investigator is a woman. I'm frustrated in trying to attract minority candidates to the panel. We have had a fair amount of success in the district increasing the participation of women on the panel, but that's still, again, a work in progress. I'm not satisfied, still working.
I would say a work in progress also in the District of Vermont.
A little bit closer.
I would say it's a work in progress as well. It's not a very diverse state in general, frankly, so that's part of the problem.
So when I became the defender, there were I don't remember how many women attorneys there were, but there were no minority attorneys in the office, and there's not a lot of turnover, and I guess there's still 6 attorneys who are still there from when I started. There are now 20 lawyers in the office, 13 are white, 7 minority. That's assistant defenders. There's 10 men, 10 women. We have 5 research and writing attorneys. 1 is a minority. They're all women. We have 6 investigators and 5 paralegals. 4 are men, and 7 are women. The 5 are minorities, and so it's gotten a lot better than when I started, and over time, hopefully, it will continue to improve. But honestly, I'm proud of what we've been able to accomplish in that time, and I think that it has helped us in court. I think it's helped our clients, and I think it's helped us attract minorities and women to the panel. The panel is still very much a work in progress, so much so that, and again, more with minorities than women, but both still. I've been working with our CJA Management Committee. I'm a member of that, to revise our training program and model it after what seems to have had some success in the Southern District of New York, and we're hoping to start taking applications for that by September. The Board of Judges have to approve the final version of that, and it will state explicitly that it's open to everyone, but the object is to increase minority representation on the panel, and it'll be modeled, as I said, after the Southern District program, which sort of mirrors that the buddy suggestion that was one of the members of the last panel made. And we're already reaching out to minority bar associations, getting into some of the judges, have identified a couple of candidates, and hopefully, with time, that will change. One of the other, well, I'll leave it at that.
Diversity has always been important to me, and we have 9.
Can I ask you a little closer?
I'm sorry. Diversity has always been important to me. We have 9 attorneys, AFPDs, including myself as the defender. 6 of the 9 are women. 3 are African American, including myself. 2 being women, and 1 is a supervisor. We have 2 research and writing attorneys. They happen to be both women. 1 is of Middle Eastern descent. We have Hispanic in the office. We used to have an Hispanic AFPD, but he left to go into private practice. With respect to the panel, we struggle, and we talk about this on the panel, the committee for the CJA panel in my district, and we're always trying to recruit minorities to the panel, both women and people of color. We have undertaken a mentoring program, but yet we still struggle to fill the void there. We do have, it's a small panel, 23. We do have 1 African American male. We used to have 2 on retired due to an illness. We do have several Hispanics that we particularly recruited from other districts to participate in the panel. So I think we have made great strides, and we continue to believe that such strides are important not only in my office but across the entire program.
Kathy, I do have one quick question.
Go ahead.
There's a statute that provides that the U.S. Marshal Service will provide transportation one way for people. Has that posed problems for any of you? Because you either get them here, but you can't get them home, or vice versa. Somebody gets them there, but they can't get them back to you.
Yes.
Yes.
Yes, definitely.
How do you deal with that? Do you use it out of your pay for it out of your coffee fund, or put them up yourselves, or just say they're on their own? Or?
We have taken out of a fund and taken up a collection, have done that many, many times in Vermont. Done it for a couple of years, at which time the U.S. Probation Office announced that there was a fund that they had there that had never come to my attention before to do that. Second Chance Act money is what I was told, and then that didn't seem to last for a while. It sort of dried up because they were using it for other internal probation things too, legitimate, obviously. And no, I mean seriously, I have no reason to question that. But
It was just amusing that you had to note that.
I didn't want to be casting aspersions by the way I said that. And it's a problem. Every now and then I'll see an order from another district on a Rule 5 case where a judge in another district has allowed for two-way transportation. I always think that's kind of cool, but I don't see any precedent in statute for that. So.
All right, thank you.
All right. Anybody else? Dennis, anybody? On behalf of the committee, thank you very much. It is very late in the afternoon, so we do appreciate you guys being here. I want to tell all of you, if there is something that you think of, I think it was Judge Goldberg who said you need to figure out a way to solve all our problems. So if you do, please, if you have any great thoughts, if you think of something that you wish you would have said, or anything that sort of stimulated further thought, please feel free to get it to us. You can either send us it in writing or communicate with our staff. But on behalf of the entire committee, thank you, and thank you for your time.
Thank you.
Thank you.